All right, welcome again to the SERMAPod. I am Rich Lenkov. I am the founder and CEO of the Sports and Entertainment Risk Management Alliance. I'm also the host of the SERMAPod. We're very fortunate today to have esteemed trial lawyer Rachel Fiset. I told you I'm going to try the name, and as I think about it more, I might butcher it, but Zweiback, Fiset, and Zalduendo. How's that?
It works.
Pretty close?
Pretty close.
Well, as a Canadian, I should nail your name more than the others. Fiset.
That is a better pronunciation than I have of my own name. It's Zweiback, I think you're struggling with.
Zweiback. All right, Zweiback, Fiset, and Zalduendo. The website is zfzlaw.com. Rachel's all over the media talking about lots of important cases. The one we're talking about today of interest to our listeners and our viewers is the ongoing issue involving the shooting on the set of Rust. Rachel, you and I have talked about this case on my other podcast before. What's in the news lately is the Rust producers, the production company, has denied liability in a filing with the New Mexico Safety Agency. Perhaps you could explain to our listeners and our viewers what the allegations are against the production company by the state and how the production company, one of the defendants, has responded to that allegation.
So this is the state OSHA department that comes in when there is a serious injury or death at any workplace. And so this clearly qualified under New Mexico, and they came in to do a wide-scale investigation, separate and apart from the DA investigation, but I can assure you it was in conjunction with the DA investigation, the way these things go down. So they interviewed people, they went through all of the evidence, and they did all of this not to have a criminal penalty at the end, but to levy what they can do, and what they can do is levy a fine on behalf of the state. So they levied their largest fine on behalf of the state, which was approximately $137,000, saying that there were extremely serious safety concerns on the set. And they went through in pretty big detail what those safety concerns were and created a chronology of why the higher ups and the producers at Rust should have known there were safety violations, including gunfire, on the set of Rust. So they detailed what safety training was done, particularly what wasn't done, what the Gabrielle Pickles they named individually, which was in charge. She was in charge of the armorer. They named her knowledge. Basically, they set it up so that each person that had knowledge of safety concerns on the set was named in their violation. And at the end they said Hannah Gutierrez Reed, the armorer, had basically tried to get more training, was denied giving more training, but that everybody knew that there had been misfires on the set before, that people had quit as a result of safety on the set, and that they were not remedying those violations. So the conclusion was this fine, the most serious they could levy. So what happened in response, as the producers have the ability to respond to this, because they are now not accepting that fine and accepting that responsibility, is they have denied liability on the set, and they are specifically citing that the armorer was an independent contractor and not an employee, so that she was not in their purview of control.
So it's really interesting and not a surprising defense, really. But really, I don't think, perhaps everyone understands that dynamic necessarily if you're not thinking about the relationship between a production company and actors and crew members, right? And what's of particular interest to a lot of our listeners and viewers is that very assertion, because it is true, frankly, as someone who represents production companies and entertainment entities, that generally these individuals are not your employees. They're not the employees of the production company or the production. They are considered independent contractors. So from a legal perspective and from an administrative law perspective in this case, because again, right now we're only talking about this administrative action by the state against the production company. We're not talking about, although we will in this podcast, the civil action and a potential criminal charge against these individuals. From an employer-employee relationship, there is, I think, some merit to the defense that the production company has put forth.
There is some merit to the defense that they've put forth. And I think when we think about a movie production, hiring multiple independent contractors makes sense. These are not permanent jobs. These are jobs that are done at a limited scope. They're done for a specific production, and they're done in specific locations. So what a movie production comes in and does is they hire all of the needs out. They don't have these people generally on staff. And in this case, they hired out, as they do, various types of people that are in charge, in their words, that are in charge of various types of aspects of the production. And so their defense here is, hey, we hired an armorer. It is her job to be in charge of the guns. And because she's not an employee, and because generally speaking, an employer is not in charge or liable for the acts of an independent contractor, the fact that she did not do her job and she did not check all of the safety ramifications of what was a loaded gun on set, it's her fault. It's not ours. We hired this position out. And that's where they are.
Now, the counter to that, of course, it's a viable defense. It might survive, a motion for summary judgment or whatever the equivalent is in this administrative procedure. However, the counter to that, and the key, I think, language from the state's perspective is they said that the production company demonstrated a plain indifference to the welfare of the cast and crew. So you can't simply hide behind the defense as the production company that I hired these individuals, they should have been trained, if there's evidence that there were other incidents or other safety violations on the set. That's the key. And if the state can show that there was some notice, it all comes down to notice of some issues in the past, then I think the defense that they put forth will be far weaker, right? This independent contractor idea will be far weaker, because once you're put on notice, the fact that you did not employ these individuals is secondary to the idea that you knew about some dangers and you failed to take steps to remedy that, and someone died. That's a pretty, simple cause and effect from the state's perspective.
I agree with you, Rich. I think that maybe it meets a prima facie case, as you said, but I think the state did a very good job laying out a few things that would be relevant to an independent contractor analysis. And one is whether the armorer was in control only of her job, or if she was taking direction from higher ups. And within the report itself from the New Mexico Environmental Board, it pretty clearly states that she was taking quite a bit of direction, and that direction was specifically, there's no more time for training on guns. And the fact that they were doing that when she's actually raising issues to them, showing that they had knowledge of these safety concerns, all that is a factor that cuts against her being independent from them. The other factor would be looking into how she was hired. Did they negligently hire her, knowing that she did not have enough experience on this set? And doling out a job to someone who's inexperienced and then ignoring safety concerns in what is such an important and potentially inherently dangerous job, I think it's hard to slough that off with a legal technicality of this person was called an independent contractor.
Now, I agree wholeheartedly. So moving on, Rachel, from this administrative hearing, where frankly the numbers, the dollar, as you mentioned, I mean, there's a cap here. So while it's not an insignificant fine, the real money in this case, the real liability from a pure dollars and cents perspective, because unfortunately, someone died. The only way to really quantify that loss in lawsuits is money. So the real damages exist not in this administrative hearing, but really in a civil case, right? And there have been multiple civil suits filed already involving a multitude of defendants. We've seen Alec Baldwin, again, the actor who was involved in this shooting, who, depending on what the evidence proves, either pulled the trigger or was at least holding the gun when Halyna Hutchins got shot. He's one of the defendants as well. He's already moved in arbitration to shield himself from liability, basically saying it wasn't my fault, right? It was either the fault of the armorer, as you mentioned, the director, producers. Where do you see this all playing out? Of course, this will all take time. Civil litigation takes, far longer than the administrative hearing we've talked about. But a lot of what goes into any civil lawsuit of this kind is the degree to which people can pay. As we just talked about, the plaintiffs are looking for recovery, and that recovery is in the form of damages, right? So where do you see the potential liability with these different defendants?
I think that
including the armor.
Yeah, so I think the producers are the most likely on the hook for most of these damages where they should be. Obviously, the Hutchins lawsuit is where most of the damages lie. And then these other suits for people that witnessed such a horrific event, I think they're making their way through the court system, and they're less likely to have the massive damages that the armorer will have. However, I think that Alec Baldwin may just start settling some of these out that are less expensive suits if the arbitration doesn't go his way. I think it's hard to say point blank there's absolutely no liability for the person that was holding the gun, specifically if he pulled the trigger and he ignored some safety considerations in doing so. And I think that determination is to be seen as to what a reasonable person would do under a negligence standard. So I think he's still potentially on the hook, as he's likely one of the deepest pockets. There's obviously insurance money as it relates to the other lawsuits, but I think that this may go beyond what they are insured for. So I know the judge in the Mitchell case threw out a host of claims as it related to what would be intentional torts or more a little more difficult towards assault and battery for a woman that wasn't hit, etc. But the negligence is going to be there, I think, no matter what. I think it's hard to get away from negligence in this case.
Rich, we talked a little bit earlier about the potential criminal liability. We know that the Santa Fe County District Attorney's Office is still investigating. That has frustrated many involved, that investigation has not yet resulted in any charges. Why do you think the investigation is taking this long, and how do you see that? What do you see the outcome of that investigation? Who will we see charged with a crime, if anyone?
Well, I do a lot of white-collar criminal defense, and this is squarely in that realm as it relates to this case, as I think, criminally speaking, for sure, intentional acts have been fairly ruled out. So this is a criminal negligence case, and those take a long time. So I know we're almost a year in. I think we are close, but as far as timing goes, we are in the wheelhouse of what is normal in making a large charging decision like this. So I don't think the DA's been particularly slow. I think they know they have an enormous fight on their hands and they want to get it right. So I know it's down to some sort of FBI phone records evidence that they are waiting on. And they were waiting on ballistics of what were the other shells found as it relates to perhaps other live rounds that were fired on the set, which I think is hugely instrumental in making these decisions as it relates to what was going on the set and the degree of negligence, like gross negligence, as it relates to this incident. I think they'll look at who was actually in charge of safety. I think the same named producers in the New Mexico report are being highly looked at. I think Dave Hall's is a little bit hard to avoid if there is a charging decision. I find it difficult that it would skip him. And I think that the armorer herself is probably on the cusp as it relates, but they are most likely looking at what kind of authority she actually had to make real change on that set. And then as it relates to a charging decision, they're going to get the person who had the actual authority to make change and evaluate what was going on once they had the knowledge that there were all of these safety violations.
And again, so we're clear, and for our listeners and our viewers, and it's interesting in the wake of the lawsuit we heard about yesterday in the New York by the New York Attorney General against Donald Trump. I mean, that is a civil lawsuit against the ex-president. She referred it criminally to the FBI, the IRS, for a potential criminal charge from the same acts or omissions by the former president. In this case, we're talking about civil liability and civil negligence. And in addition, for the same acts, there could be criminal negligence. As Rachel said, there doesn't seem to be any strong evidence that anyone intentionally was, putting bullets in the gun or pulling the trigger. Even though there's been, some wild conspiracy theories, that doesn't seem to be a track that the DA will take. However, to your point, they may very well and are likely to pursue criminal negligence as a theory. Rachel, one interesting side note that you mentioned that's really, again, of interest to our listeners and our viewers is the insurance piece. I think people think that the individuals that are named are going to have to pay out of pocket. They very well may, and liability may exceed the policy. But, we have a lot of insurers in our organization, and it's important to remember that there is insurance for this kind of act generally, but that insurance doesn't cover everything, right? If there's proof that there was willful or wanton conduct, that could obviate any policy. And importantly, there is no insurance for criminal acts, obviously, right? I mean, there is no insurance for that. So that's interesting to think of that. I don't see much discussion out there.
Right. So if there's a criminal charge and a conviction, it would have to go to conviction. Insurance at that point might seek to get any money back that they had advanced as it relates to these policies. So, but we are way down the line for that kind of action because, again, this is the same case as you mentioned, Rich, and this is really an area that I do a lot of, which is the same case is tracking criminally and civilly. And that has a lot of implications, particularly for your civil case and how that is handled, because any evidence given in a civil case is immediately turned over to prosecutors to help them in their criminal case. So in a way, they'd be somewhat wise to settle some of those civil cases before they reach mass discovery if this investigation is still going on or a charging decision has been made against a named defendant in one of the civil cases.
So that, Rachel, is a really interesting point. Again, in this podcast, in our organization, we strive to meet the goal of providing content that you're not hearing otherwise. And I'm not hearing a lot of in-depth discussion in this case about the liability that any of these defendants can face with the same evidence in both cases, right? So let's take an example, the armorer. If there is evidence discovered civilly that she was negligent, that she wasn't trained properly, that she wasn't paying attention, that she was, not paying attention that day to the guns being used on the set, that could be a problem for her civilly also that could be used in a criminal case against her for similar charges, right?
Exactly. It's all the same evidence. And you bet that any plaintiff that is bringing a civil case absolutely wants any of their defendants criminally charged. So they are often, in a case like this, working behind the scenes with the prosecutors to provide them with any information that they can. So anything obtained in that civil case, it's going to apply to the criminal case just because the incident that they're discussing is the same. It's just the standards for civil cases and charges criminally are different.
Rachel, our members, many of whom will be listening to this podcast, represent some of the most well-known brands in the world in some cases. We talked about the litigation pending against the former president. That will assuredly be one of the most watched high-profile cases in history if it goes to trial. We're coming off the Johnny Depp trial, which arguably was the most followed trial in history, given the social media and the length of it. You are very familiar and very experienced for years and years representing many high-profile defendants. The former sheriff of Los Angeles County, for example, was one of your clients. So my question to you after that very long buildup is, what are some of the challenges involved in representing a high-profile defendant in a case like this, both criminally and civilly, right? If any of the Rust defendants go to trial or even, proceed down that route, there are challenges different from representing your run-of-the-mill defendant. Explain some of those to our listeners.
Well, the biggest challenge is the media and how to handle the media. And it also is a bit client dependent because you're a high profile client, whether they be a politician, an actor, or some other high profile client that may have a business riding on the allegations that are out there, a high profile business owner as well, is that they are used to sending a direct message to people. And in sending a direct message to people when you are being scrutinized by either civilly or by prosecutors, is that anything you say is scrutinized. So that is, it becomes a very difficult balance in weighing who is talking, what they are saying, and when it makes sense to do so. Because a lot of times the media is coming at your client and you at your case and, really making you sound terrible. And there's a natural instinct to want to defend what's being said in the media. And I think sitting back and truly and strategically going through what might be said to counter it, or what other types of acts without direct speaking that can be done to counter that perception, if it makes sense, is really a very strategic, a very high level decision. And a lot, it take each discussion and each interaction with the public in a high profile case needs to be well thought out. And that's the difficulty.
So to that point, Rachel, if you were representing Alec Baldwin, who's obviously the most prominent figure involved here, and who has also been very vocal in media, right, since the shooting. He has spoken repeatedly about the shooting and talked about very openly his feelings on liability, his feelings on who's responsible. Would you counsel him to stop talking? And what effect does all of this media have on his potential liability? I mean, how would jurors consider what he's saying? I'm sure it could only hurt him, is my thought, but I want to hear your opinion, having been in those rooms before.
Oh, yeah. So I think there's always a psychological component to what's going on with a client. And in this case, it's very serious, and he is responsible, in some way for the death of Miss Hutchins. Obviously accidental, but that has to be weighing on him through time. And he has been pretty clear how he's presenting, how he feels about that. And I think that has made him want to speak a lot to the media, to his public that he's used to talking to. I agree with you, Rich. I don't think those messages have been particularly controlled in a way that it's helpful, particularly when you get into facts in the media, and then those facts are disproven or disputed by investigators. That is not a good look. Getting into facts is pretty much a never ever. Getting into some sort of message that it might make sense is possible, but getting into the nitty gritty facts of an investigation, and I'm specifically in this case talking about him saying he never pulled the trigger and the FBI coming out and saying he must have pulled the trigger, I think that is not good for his case, because in truth, it may not really matter if he pulled the trigger at the end of the day, but now you have this disputed issue in the public, and that's not good for the public, and that's not ultimately good at a trial.
Rachel, last question. Fascinating input. We really appreciate it. Last question here on the SERMAPod. We've covered the entertainment portion of our podcast. I would be remiss if we didn't talk about the the sports part, by noting that you were a former nationally ranked junior tennis player, played on the Purdue University women's tennis team. We just saw arguably the greatest female tennis player of all time, Miss Williams, retire. Quite arguably the greatest tennis player of all time retire. We've talked about this a little bit on some other podcasts that we've done, and the influence of Williams. Maybe talk to us about your perspective on her impact on the sport, and whether we'll ever see anyone like her again. I think she's, a once in a lifetime phenomena, and are incredibly in awe of what she's done. But I'd love your perspective, given your history as a tennis player.
I'm so proud of her. I grew up with a lot of tennis professionals. I played with the people my age, Mary Pierce, Lindsay Davenport, Capriati, all of which were amazing players, which I would play in Florida tennis and junior tennis tournaments. And it is so difficult to get to 400 in the world, let alone number one in the world. So first of all, my God, she is amazing. What a feat. But to go from there and to truly be authentic, be yourself, and change the game in a way that racially, the racial component, and to fight people in a traditionally white sport, to get fans on board, to pave the road for other African American tennis players, and to do good in that community as well, to inspire it and truly put your money where your mouth is. I don't think we will see another person like Serena Williams. And I don't know, because she has been such a change maker, that we even need to see another person like Serena Williams. Now people can follow in her footsteps and be above where she started. And so the change just keeps going up. So, I am so impressed by her. I know there's a lot more to come. And also, as a woman who's had children, 41 after a baby, coming back like that, all of it. So I don't know how, I'm in awe. I have no idea how all of that happened.
Amazing. Well, very well stated. Rachel Fiset. I'm going to pronounce it Fiset as a Canadian. I'm not going to say Fiset. I've asked you before if you're related to the former goaltender for the Canadians. Maybe check your lineage. Perhaps you are related. But Fiset in Quebec, where I'm from, is like Jones. There's a lot of Fisets around. But ZFZlaw.com. Again, Canadians would say ZFZ, but I will use the Z. Thank you so much for joining us on the SERMAPod. We really appreciate it. And please, as this story progresses, which we know it will, please come back and update our listeners and our viewers on this very interesting story.
Thanks so much for having me, Rich. This was a pleasure.
Ideas, strategies, and opinions represented on this podcast are those of the speakers and do not represent the ideas, strategies, and opinions of their employers.